number 125, the people of the state of New York versus Rodney Watts.
Good afternoon, Your Honors. May it please the Court. Ariel Reed for Defendant Appellant Rodney Watts. With Your Honor's permission, I'd like to reserve 2 minutes for rebuttal.
2 minutes?
Yes, Your Honor.
You may.
An event ticket is neither a deed, nor will, nor contract, nor commercial instrument, nor credit card, and it does not evidence, affect, transfer, or terminate a legal right, legal interest, legal obligation, or legal status.
What's the difference between a legal right and a legal interest?
Your Honor, my understanding is that a legal right is a right that is created by law, it's recognized by law. A legal interest is similar in the sense that it's kind of like a legal title. It's also something that's recognized by law, and I think that's the underlying...
Well, here, it's my understanding that everybody agrees that this ticket conveys a revocable license.
Yes.
Why isn't that, I mean, that's not something that one would ordinarily talk about in ordinary parlance. To me, that seems like what I studied in law school, which has to do with legal rights and or interests. So what's wrong with that analysis?
I think Your Honor is completely correct that the term license is not something that people go around saying on the street. It is something that...
driver's license.
Yes, other than driver's license, yes. The license in the terms that we mean it is not something that normal people just say in everyday conversation. But to put a license in everyday conversation, a license is purely permission. It's just a fancy way of saying permission.
Well, why isn't that, having permission, isn't that a legal interest?
No,
let's just use the example of it's between strangers. It's not like a mother giving permission to a child, parent giving permission to a child. It's strangers at arm's length. Somebody pays for something to get something. And isn't that something that they got, which is represented by this ticket, doesn't that give them a legal interest? It gives them permission to go to this place at this time and maybe sit in a particular seat?
I think, Your Honor, I think your distinction that you're drawing is particularly relevant when you consider the second-degree statute with the third-degree statute, which is what our position event tickets fall under. So the third-degree statute actually reaches these types of relationships that don't arise to legal, rights, legal interests, or legal obligations. The third-degree statute does prohibit forgery of symbols of evidence of value, right, privilege, or identification. So clearly the legislator intended a distinction between something that is a legal right, legal interest, or legal obligation, and general kind of privileges that, between strangers or between family members.
Why isn't it affecting, because the word is affecting a status? I buy the fraudulent ticket, to my misfortune, but I thought it was a real ticket, which means it would change my status from a trespasser if I try to walk in to someone who, I think even under your rule, you would concede has some interest that might be recognized because it's a revocable license to go in and see the concert, let's just say a concert. Why isn't that affecting a status?
Your Honor, it could be affecting a status. Whether it affects a legal status, I think, is the question here. And
well, trespasser versus someone who, at least on its face, can request entry.
Yes, Your Honor. So somebody who has a ticket, the ticket itself is not the thing that changes their legal status. And I think the Marone versus Washington Jockey Club.
No, but it's an instrument, right? It's an instrument that affects because it's representing.
Yes, Your Honor, it's an instrument, but the facts of that case, I think, are on point here, because in that case, the defendant bought a ticket for the racetrack. Previously, he had been told that he was not wanted in the racetrack, but he bought a ticket anyway, and he showed up at the gate, and he had his ticket, and he's like, I bought a ticket, I'm not a trespasser, I have the right to be in here, and they excluded him because they told him, regardless of whether you have a ticket or not, the supreme determination of whether you are allowed to come in here or not is
That's a revocation. They revoked.
So they revoked the right. So he may have the ability to seek compensation for that right because you were denied it, whatever the value of the ticket was. But that's not like saying he had no legal rights at all. Doesn't your argument really require us to say that the catch-all phrase at the end doesn't apply and that we have to analyze the case purely in the matter of the canons of construction and in the justum generis?
I think, Your Honor, I think a justum generis is apt. I think that's.
It seems that that's the only way we really get to what you're saying, which is, because otherwise a plain reading of the catch-all phrase seems to include this kind of item. But if it wouldn't, if a justum generis were strictly complied with.
Your Honor, I think, going to the justum generis point, I do think that justum generis controls here. I think, the fact that the enumerated instruments in the statute are things like deeds, wills, contracts, things that, from a Lockean perspective, are foundational to our society and our
So
economic
what would
system.
another example of an instrument be?
Any example? What's any example at all, or is there
Yeah.
something along the lines of tickets?
Yeah, if a ticket
or-
isn't, no, in your interpretation and your view.
An instrument that is not
Would
affecting
fit
a legal
in
right.
with-
Okay. I think, for instance, a acceptance letter to a university that could be forged, and
Well, there's the one case, the forgery case of a job application letter, right? Can't remember the name of the case right now. Do you remember?
I'm thinking of one for a barrister application. I'm not sure if that's the one that you're thinking of. And for
I may not be sure, but there are the number of cases going, that doesn't seem to be a legal instrument in any sense of the word, but there are things like gift cards, credit card receipts that have been held to apply under the statute.
Yes, Your Honor, credit cards are actually one of the enumerated instruments
Credit
in
card
the statute.
receipts now and a gift card, similar to a credit card.
The understanding of, between credit card receipts as being that type of instrument is the fact that with credit cards, you're signing and agreeing to pay something, you're entering into a contract with the bank. Your signature reflects the fact that, you are responsible for paying that.
So let me ask you this. If an instrument's capable of conveying a proprietary or a monetary interest, then would you concede it's covered by the statute?
If an instrument is capable of conveying some sort of legal proprietary interest, and I would concede that, I don't think, and this court has recognized that tickets don't convey legal rights to go or remain in
The thing
venues.
is there are legal instruments that you don't need a specialized legal procedure to transfer contracts, like a bearer bond, something like that. They can just be transferred cash. So it's not always the case. It's not clear cut, is what I mean.
Your Honor, yes, cash you definitely don't, need some kind of
Well,
special.
bearer bond.
Yes, Your Honor, but I think the idea is that tickets, they're basically receipts for money, basically. It's evidence that you paid an entrance fee at some prior time. It's basically it's merely
Yeah, but
a
if I walked in
convenience.
with the receipt from the purchase of the ticket, that's not going to get me in. I'm going to have the ticket. They might send me to the window and see if I can work something out, but I can't walk up to the ticket collector and say, I can't find my ticket, but here's a receipt that shows I purchased a ticket. I can't use that.
Your Honor,
What about a ticket that has a designated seat? Does that make that different from just a general admission ticket?
I don't think so. I think that even if it has a seat on it, you are not, the proprietor is not obligated to let you sit at that seat. You're still not obligated to enter.
Back to that. Let me ask you this. Why isn't it a commercial instrument?
Your Honor, a ticket's not a commercial instrument because it's basically a convenience. It doesn't have any sort of inherent value or power, or it doesn't convey any sort of monetary interest, proprietary interest, legal interest. It's just a piece of paper that says that somebody at some point paid something to come into this event, assuming even then that it's a ticket that people pay for. Because
And then the bearer of the ticket gets to request to enter the event, no?
the bearer of the ticket gets to request to enter the event. They can either be let in or not let in based on the desires
It's
of
revocable.
It's
It's
revocable.
not an irrevocable license.
But there may be consequences to not letting them in, legal consequences. They may be liable for contract damages.
Your Honor, the only remedy at law for being denied entrance, or the only curb on the right of proprietors to deny someone entrance, is within the extent of civil rights law. The law is clear that proprietors retain the power to always revoke tickets at their leisure, as long as it's not in violation of civil rights statutes.
But not without some possible remedy.
There are potentially remedies, Your Honor. You can, but those are very context specific. At best, like I said, you could ask for a refund, but not all tickets have prices. I've been to many events where tickets were free, and at that point, if you have a free ticket and you're told you can't come in, what do you get from that? There's nothing to gain. There's no remedy at law on the ticket. There could be, a remedy based on a transaction, but that's, just general principles of transactions. It's not something that's inherent and specific to event tickets.
Thank you, counsel.
Thank you.
Counsel?
Chief Judge, and may it please the court, Lee Pollack for the people. We've said the word might a lot here, and I think I need to step back and resituate ourselves, because we're talking here about an indictment case. Defendant's argument is that there was no ticket that met the description written in these indictments that could possibly have allowed a prosecution to proceed.
That's why you're here, right? Without that, you wouldn't be here. It would be jurisdictional, your jurisdictional argument.
I'm sorry, Your Honor, I'm not understanding the question.
Go ahead.
So I just want to step back and make the point that because we're, yes, okay, I think I see where you're going.
Sorry, go ahead.
The defendant's plea would have waived his claim if it weren't for that, the nature of his argument. And so when we talk about, well, some tickets aren't refundable, some tickets are to free events, that doesn't get us across the line in this case. It is enough that any ticket described as a ticket to a Coldplay concert, a Rihanna concert, a Knicks ticket, the tickets that were actually named here, which, let's be honest, common sense tells us cost a great deal of money, as revealed by how much defendant was able to get for them on the street.
So would it be a defense that I didn't pay anything for this ticket?
It might be. If defendant can argue that this thing that we all called a ticket was actually not something that fit into the plain language of the statute. And that's where we come back to the plain language of this statute covers this document. This document, a ticket of admission absolutely does, at a minimum, transfer and evidence a legal right, a legal status, and a legal obligation. The legal right is the right to enter, and this court has held so in People v. Licata, in Collister v. Hayman. The legal obligation is the obligation incumbent upon the venue to let the bearer, not necessarily the person who paid, and thus the critical distinction between the receipt that you get when you might pay for the ticket and the ticket itself, let the bearer attend or provide the bearer a refund. And this court has held that as far back as People ex rel. Burnham v. Flynn, Aaron v. Ward. And the status is the status of a licensee, which is, to wit, not a trespasser, not someone who may be thrown out freely. You first got to, and this court said
it's revocable, so it does not ensure that you will get admitted, but it does give you a different position for someone who has no ticket to go and request entry.
Right. Someone who enters without a ticket is already a trespasser. The police may already be called. They have already completed
Unless there's
a
consent,
crime.
yes, right.
Whereas somebody who merely who has a ticket, the revocation must take place, and that revocation has legal consequence. It gives a right for a claim of breach of contract. Whatever the terms of the contract were, will define what that claim for breach is worth. Maybe it's worth a refund, maybe it's worth more, maybe it's worth less. That's defined by the terms of the contract, and this gets to the justum generis issue. This ticket, even if it's not a contract, and I have some concerns about this, yes, there is some precedent from this court dating back from 1904 that says the ticket is not a contract, it is merely evidence thereof. I don't know whether that still holds in light of modern understandings of contract law, and I don't believe this court needs to revisit that in order to find in our favor, but I do note that I'm not sure that's true, especially if, say, on the back of the ticket are terms and conditions which meaningfully limit and are only present there.
Well, you're right. It's a little bit muddied between contracts and property interests that we know as licenses.
Right.
Granted, yes.
But I think that the point that I'm trying to make, I may not be succeeding, is that if it is not a contract, it is so so close and so inextricably bound up in the contract that everyone acknowledges did have to form.
Well, I don't know that you have to work that hard. I mean, basically licenses, revocable, irrevocable, they are a property interest of sorts.
I agree with that as well.
Thank you.
I at least can catch a softball. Or I humor myself.
Because there's no negotiation in the contract.
No, but it's a
about the
contract of
ticket. Although
adhesion.
perhaps in this case, because maybe he's asking for particular money and they hassled over that on the street. Who knows? Haggled, excuse me.
Absolutely.
So what about if I forge the expiration date on a jar of yogurt so I can return it to Whole Foods?
I'm not sure what legal
Well, Whole
right.
Foods, let's say they have there's an implied understanding the grocery stores, if you purchase something where they fail to take it off the shelf after the expiration, will take it back. Whole Foods, in fact, will do that.
Again, I don't see how the law could ever step in, and so I don't see how that ever becomes a legal right, a
Right,
legal
what if
status.
what if it's milk, which is regulated, and you can't sell milk after the expiration date on the top? That's
I
by
still
law,
don't
that's by
know that
statute.
it's a legal, I mean, it's an interesting hypo. I
Well, the
haven't thought
people
of
have to show it's an instrument. How's a
Well,
yogurt an
yes, I think
instrument?
we're back in People v. Vu. Your Honor, by the way, People v. Sengupta, I think, is the case you were thinking of. We're back in People v. Vu. A handbag can't be a forged instrument because it isn't a writing. And if a bottle of milk is also not a writing. But I think that if the date on the bottle of milk, I don't think that's a term of any legal relationship between the supermarket and the buyer. Maybe if you were the seller, if you were the dairyman, and you were selling milk that had been marked falsely with its date, such that it was a term of your contract with the supermarket that you would only sell the milk that was 3 days old, and you forged 3-month-old milk to make it look 3 days old. Maybe the law would step in. Maybe that does point to a legal right, but even there, I'm not sure, and I don't think I need to answer this question to get I don't think you need to answer this question to resolve this case. I think beyond that, everything else is set out in our brief, and we would stand on it. If the court has no further questions, we ask you to affirm.
Thank you, Mr. Pollack. Ms. Reed?
I just want to touch briefly on Judge Wilson's point about the milk or yogurt carton. I think that's the problem here, is that when you make any transaction anywhere, whether it's for a ticket or something else, there's always going to be a possibility that if something's wrong or something happens with what you purchased, you can get a refund. I don't think that the ability to get a refund is the kind of right, in quotes, that the legislator was trying to reach here. And again, a license is a privilege, and according to the New York jurisprudence, it is the lowest order of privilege, and the word privilege is in the third-degree statute.
Well, you're not saying that it couldn't fall within both third degree and second degree, are you?
I am, Your Honor. I don't think that.
I thought the whole way the statutory scheme was set up was that each one included everything.
Sorry, Your Honor. Yeah, I misunderstood your question. So the third-degree statute is the catch-all for everything else not enumerated in the first and second degrees. By definition, anything that falls within the first or second degrees could also be included in a third degree. But the alternative is not true. So I think the legislative history here is important. When the legislature adopted the current penal code, they did so particularly with forgery statute, because the prior code had been comprised of a mishmash and hodgepodge of miscellaneous instruments just listed one after the other. And the point in making the statute this way is so that very discrete instruments would be included in the first and second degree statute, and then the third degree could just encompass everything else. That was the purpose.
Also, I'm sorry, also including, I guess I'm not clear on the answer to Judge Stein's question, but the third category would encompass everything in 1 and 2 as a catch-all?
The third degree statute, yes, Your Honor, is a catch-all.
So if it made 1, it would also qualify under 3?
Yes.
Okay.
If it made 1, it would qualify under 3, but if it's in 3, that doesn't necessarily mean that it's
Understood.
1.
Thank you.
Yes, yes. And I also want to point out that people aren't selling.
So if it's in 1 and 3, it's the prosecutor's discretion, correct?
If it's in 1 and 3, it's the prosecutor's discretion, Your Honor. I do want to point out that people aren't selling, deeds, wills, contracts on Craigslist because you can't. You can't sell those things. Those aren't the types of instruments that you can put an ad on Craigslist and say, come pay me for this contract.
So is it, one of the things I was interested about was what other states did with non-pecuniary instruments. Did you look at that at all?
Yes, Your Honor. There were 12 states that had statutes, if not identical, then very similar to New York's. Two of them, with particularly Kentucky and Alabama, do not include event tickets within the second-degree statute. They include it it's a third degree. It's a misdemeanor, basically. 6 other states that don't have the same language also consider tickets a misdemeanor and not
It
a
seemed
felony.
like many of the ones I looked at in the research that was done, there seemed to be a divide between pecuniary and non-pecuniary instruments, and that's the way the statute seemed to be structured.
Pecuniary, yes, Your Honor. I think the pecuniary instruments are instruments that, since the very beginning, have been considered instruments of such high importance that they've been included in the forgery statutes, like money and deeds and wills and those types of instruments. Event tickets in New York State have never been considered a higher degree of forgery.
It's a big business in New York.
It is a big business in New York, Your Honor, and I think that's
It does.
part of
Those
the.
Beyonce tickets, they're pretty valuable.
They
apparently.
are. They're valuable here and everywhere, honestly. It's Beyonce. I think that's part of the problem. And if this court fashions a rule that tickets give legal rights to their bearers, that would actually undercut Broadway, sports teams, theaters, any types of events where, tickets are used, because let's say Beyonce gets sick and she can't perform, then is the person who has the ticket going to say, I had a legal interest in this
Says right on
performance?
the back, throttle up.
Or if the star quarterback gets injured the day before the game, are people going to have a claim of right to sue?
Thank you, Ms. Reed.
Thank you.